So I suppose doctors, GPs face medico-legal dilemmas on a daily basis. One of the most common, I suppose, there would be requests from family members to discuss a particular patient. And that's, I suppose, a difficult dilemma for doctors, because it's understandable that they would like to discuss particular patients and their case with family members, but it's very important to remember that doctors should not disclose confidential medical information to family members without the informed consent of the patient. So doctors should, in that situation, focus on obtaining the informed consent of the patient to disclosure to family members, friends, carers, whoever they would like. The only, I suppose, exception to that is if the doctor feels that the case falls within one of the 3 well-defined exceptions to the general obligation to maintain confidentiality, and they are where the patient is, there's a threat, in order to avoid, I suppose, a threat to the patient themselves or others, threat to the public, or if they're legally obligated to do so. So you're legally obligated to do so if there's a court order, for example, or if it's a situation where a person has a notifiable disease, for example, an STI. I suppose the other situation which would be quite common would be, or so doctors would think about, is that threat to the patient themselves. But that is it's exceptional to disclose information on that ground. The threshold is very high. It's a threat of serious harm of serious risk of serious harm. So I suppose doctors, again, are often faced with decisions around whether or not they feel that a patient has capacity to consent to a particular treatment in their surgery. And I think for GPs, it's very important to understand that in Ireland, a functional test for capacity operates, which means that it's decision specific. So it's about whether the patient can consent to that particular treatment and that at that particular time. So it recognises a hierarchy of complexity. So some patients might be able to consent to simple procedures or treatments, but not to more complex procedures. Other patients might be able to consent to a treatment today and not tomorrow if their capacity is fluctuating. The new Assisted Decision Making Capacity Act, which has not commenced yet, so it's not in force in Ireland as yet, but when, I suppose, the definition that's contained in that act, and we expect it to be commenced, in the next couple of months, hopefully, but the definition of capacity in that act is functional again, and it talks about that the patient lacks capacity if they can't understand information, if they can't retain it, if they can't use or weigh that information up, or if they can't communicate their decision. So that's, I suppose, a basic test for capacity. The other thing I think that's important for GPs to remember when they're dealing with patients is that there's a presumption of capacity in Ireland. So you presume that your patient has capacity, and that cognitive deficits are only relevant if they impact on that patient's ability to make a decision at that particular time in relation to that particular thing, I suppose, or that particular decision. Again, I suppose if you have a patient who lacks capacity, doctors must remember that family members cannot consent on behalf of that patient unless they have a specific legal authority to do so. That is, if they're part of the wardship committee under the current system, or under the new Assisted Decision Making Capacity Act, if they've been appointed formally as an assisted decision maker, for example. But without that specific legal authority, family members cannot consent to medical treatment on behalf of patients.